All right, welcome everyone to today's session with Tim Twigg. HR updates during, well, the bug is what I would like to call it. I'm just tired of even saying coronavirus or COVID-19. So I see we've got quite a few attendees rolling on. Tim, thank you so much for being here, and we'll give it another minute or so. We're at about 30 so far, and I anticipate we'll have quite a crowd today. So again, thank you so much. And Tim, remind me where, I know you're on Pacific time. Where are you located?
Yeah, we're in Oregon, Eugene, Oregon.
Eugene, Oregon. Wonderful. Well, the sun is out here. I am right outside of Memphis, Tennessee, and it's amazing how in crazy times like this, it's great just to get to see the sunshine, right? We begin to count our blessings. So we'll let a few more people hop on here, and then I will introduce myself officially and who we're doing this for primarily, and we'll get started.
Awesome.
Oh, hey there. So in our chat, Deborah Englehart Nash, who is a past president of the Academy of Dental Management Consultants, says hi there, friends. Hey, Deborah. All right. Well, I've got a minute after, so I want to go ahead and honor everyone's time today. My name is Penny Reed. I'm the founder of the Dental Coaching Institute. I am here with you today as a proud member of the Academy of Dental Management Consultants, along with a fellow member here that I'll introduce in a moment. Our outcome today is to share with not only with our Academy of Dental Management Consultants, you'll hear me refer to that as ADMC. And by the way, that website is admc.net for those consultants and speakers that may be interested in learning more, for the dentists that are looking for a consultant or a speaker dental related that's a member of this academy. It's a very unique and special organization. One of the things that you will notice today is the power of the collaboration when we as consultants can get together and share our expertise to help the industry as a whole. So it is my honor to be the host today. Actually, Roy Shelburne is also here participating, not on video. He is our president-elect. I see several of the past presidents. So on that note, Tim Twigg, who is our presenter today, is also a past president of the Academy of Dental Management Consultants. And Tim is with Bent Ericksen. He's going to have some slides that he will share with us after he gets started, and his contact information is in there. So Tim, I want to go ahead and turn it over to you. And actually, one more thing before I do, to let everyone know, many of you submitted questions in advance, which is wonderful. I'm going to ask if you would hold typing any questions into the queue until about the half hour or 20 minutes till the top of the hour, because Tim has allowed some time for those questions. And that way, if he's already answered your question, it will keep the queue fresh so that we're not getting bogged down with, with a lot of questions that he's already answered. So thank you so much, Tim, for being with us today.
Well, you're very welcome. Thanks for the opportunity. Let me click a couple buttons and we'll kick over the screen. So as Penny said, what we're going to focus on is this whole idea of the coronavirus and specifically the HR related aspects of it. And we're going to dive into, like it shows here, perspectives and considerations and requirements. So where this whole thing starts is, all right, what's going on here?
Oh, it's always great when technology works. By the way, Tim, while you're looking at that, I wanted there we go. I wanted to let our viewers know that this session is being recorded.
Yes. So this whole idea of shutting down, and of course, in some cases, the shutting down is mandatory or it's voluntary. In some cases, the shutdown is a full or a partial. We're getting a lot of questions from people saying, okay, well, what are the HR implications if it's mandatory or if it's voluntary or if it's full or if it's partial? The answer to that one is probably the simplest answer of any of the questions that we're dealing with. And that answer is there's really no difference. So from an HR standpoint, all of the same sort of T's that you have to cross and I's that you have to dot are the same, whether it's mandatory, voluntary, partial, or full. From a perspective standpoint, we know that there's this whole range of how businesses, practices, and certainly dentists can view this. And over on the left, we've got, well, maybe this dentist not so nice. Employees are on their own. Gosh, this is too bad, but so sad. And employees are just an expense anyway. And besides that, I can't afford to do anything. And way over on the right, sort of the flip of that, supportive and caring, appreciative of my employees are truly a resource for me. I cannot do this without them. And I can afford to do something. And that something certainly has to be tempered a little bit with what my financial circumstance and my financial situation is. Some of you might land about in the middle as you're trying to navigate this and work through the pros and cons and again, the financial considerations. And some of you land somewhere in between. And this is not about good, bad, right, or wrong. It just is just acknowledging and recognizing that everyone lands on this spectrum, so to speak, somewhere. Based on landing on the spectrum and wherever you are, some people look at this and they say, hey, it's just a vacation. Now, maybe it wasn't planned, but hey, it's just a vacation. We normally take vacation during the summer. Heck, we normally take spring break off, and this is happening right around spring break. So it's just a vacation. And others are going, well, okay, it's not a vacation. It's more like an extended vacation. So a little longer than maybe we thought, a little longer than what we planned for, but nonetheless, our context for it, our perspective is that of a vacation. And then we can say, all right, no, not a vacation. It's more like a furlough or it's a layoff. And from a layoff standpoint, we can be addressing layoffs from a temporary layoff standpoint or from a permanent layoff standpoint. A lot of times what comes up is, well, what's the difference between a furlough and a layoff? Well, the differences are really subtle. For all intents and purposes, they're pretty much the same. There are two kind of salient differences between the two. One is that with a furlough, the assumption is absolutely everyone is coming back. It's like the business has just been put on pause, and as soon as the pause button is released, everyone comes back and we pick up right where we left off or as close to right where we left off as we can. A layoff, it builds in just inherently a little more uncertainty. So a layoff is saying, well, when we open and if we have the workload and we need you, then you'll be brought back. So the layoff introduces a little bit of uncertainty where a furlough is designed to be a mechanism where there is really no certainty. There's also a little paperwork difference. With furlough, if you're doing this as a furlough, there really is not any need for paperwork because, like I said, this is just a pause. And then we're all just going to pick up right where we left off. No change in anything. A layoff means the person's employment relationship with the practice ends. And that triggers things like paying out potentially accrued and unused vacation or PTO or potential sick leave, things like that, where a furlough, that's not the case. Now, that being said, please understand that you do not get to utilize a furlough for an indefinite period of time. Most states have some criteria that says, well, sure, you can do the furlough. It's just like the pause button I said. You just pick up right where you left off. But if this furlough is going to extend beyond, and some of them will define a certain number of pay periods or whatever, then no, furloughs don't count. So they build in this idea that says, well, because furlough means maybe you don't have to pay out some things, you can't just use this with an indefinite time frame. A fourth perspective is, oops, this is things going on, or it's a little scary, or there's so many unknowns. And at that point, it's a little more of a long-term unknown layoff. And it could, depending upon circumstances and situations, involve termination. We have practices who are saying, I have an employee, this employee is 7 months pregnant. She wasn't even planning on coming back to work once she had the baby. So she's just saying, hey, what if this just starts right now and I just end my employment with you? Well, in that case, yeah, technically it's a termination, but it's all done in a really supportive, positive, and healthy way. Some of the considerations in this whole idea of shutting down partially and so on is this idea of having a skeleton crew still. This can be someone who comes into the office or some number of people who come into the office. They're going to open the mail, they're going to process payments, maybe they're going to answer the phones and do some calling. And some of this work clearly can be done from at home with remote access to the computer system at the office. Another consideration is reduced hours. Now, reduced hours can be everyone just goes on reduced hours. This is commonly called work share, so that we're all in this together and we're reducing hours for everyone across the board. It could also be that certain people, based on the nature of their job or their individual situation, maybe they are laid off and or furloughed, and some other people maintain some reduced hours. This is just all about what best supports the ability for the practice to sort of keep limping along as best you can, given the circumstances. In terms of a skeleton crew or reduced hours, I think another way of looking at this is there are some opportunities here. During this time period, you can do a deep dive into chart audits. And what about all these patients who have some incomplete dentistry and it's been diagnosed, maybe it's even been presented and it's just out there dangling. And a lot of times the question comes up, well, what about a chart audit? And the answer is, well, we don't have the time. Well, the beauty here is we have the time to do it. So a deep dive in the chart audit. The beauty of this also is it helps set the stage for a fuller schedule when you do get to open. You only have to say, okay, well, how far out into the future do we schedule where we think it might be safe, and we're not going to be spending a whole lot of time rescheduling people because of time frames relative to our ability to reopen. What about AR? What about an opportunity to work on the AR and some of the delinquent or old accounts receivable? Same sort of thing with insurance. You've got some dangling forms out there and maybe they got kicked back because something was missing on a form. Well, what a great opportunity to complete those and get them in the queue with the insurance company for processing. Hey, we could deep clean. Let's deep clean cabinets and drawers and cabinets. And what about inventorying supplies and identifying all this stuff that's old and it's expired and it's sitting in the back of the cabinet or the back of the drawer? Let's get these things identified. Let's organize our dental supplies and even have some communication with the dental supplier about, hey, I've got this expired stuff. Can we trade it out? Is there a rebate with it? How can you support us in getting up-to-date and current supplies? We can ensure that all of our medical equipment is up-to-date. Our fire extinguishers, our defibrillators, all those things are current and up-to-date. What about patient lists? And along those same lines, this deactivating of patients. We got patients who you haven't seen in 5 years and 6 years. You've done different kinds of marketing in an attempt to reactivate, and there hasn't been a response. Holy cow, some of them may have even moved, especially if you're doing some of this marketing digitally, and you may not be getting some sort of address correction. And so here's an opportunity to do some cleanup along those lines. You can paint, you can remodel, you can look at new technology and new equipment. There's lots of opportunities for virtual training, whether that's for CE or even training on some new technology or some new equipment. When you have someone who is doing some of these kinds of activities that aren't otherwise part of their normal job, you can pay them a different work rate. So the DCWR stands for different capacity work rate. And if this person, let's just take, for example, a hygienist, if this person is clearly not doing hygiene care, but they are doing a chart audit, they are calling people who are delinquent for recall, they have relationships with these people. They might be more effective actually getting people on the phone and getting people booked. I know that Deborah Nash yesterday in a call we had, she talked about how their practice has been doing this, and they've got a really full, wonderful schedule for some months from now when they're anticipating opening. So it's these kinds of proactive things that will help build a foundation now that you can springboard off of once the switch, in a sense, gets thrown. Here's just a quick little, yes.
Yeah, if I could, this is sort of a question / comment, and then I'll be brief because I know we have that at the end. From conversations that I know I've had with some of my teams and some of the other consultants on working accounts receivable, I think we want to be sure if we're reaching out to patients, and I'd love to know your input on this because some of them are also experiencing, our patients are experiencing disruption.
Totally.
I think we need to come more from a place of curiosity because oftentimes patients will ignore their statement. They think, oh, well, I have insurance, and that it's a time to connect, to check on them and see how they're doing and say, hey, you know, we're curious. If you knew about that, wanted to take the time to explain and change our approach from what we normally would. What would you say about that as far as that sensitivity and really needing to listen to the patients that may owe us a balance and they could be laid off from work?
I completely agree with you. It is a matter of making sure that there is a sensitivity to the circumstances and the situations. In a lot of practices, you know a whole lot about these people, their families, their circumstance and situation. And so, yeah, I think it's really important to ensure that you're not just coming across like, okay, you owe me money now.
Yeah, we're shut down. We're shut down, so we're beating the bushes.
Yeah, I totally agree with you.
Yeah.
Yeah.
Okay. Go ahead. Carry on. You're doing awesome.
Thank you. So here's just a little economic look. So what if we went down to a skeleton crew? And what if we only had 3 people doing some work? And what if they're only working 6 hours a day? Well, that's 18 hours per day of staff time, team time. What if they did it 4 days a week? That's 72 hours for the week. What if the average wage, a little different capacity work rate or whatever we normally pay, what if the average wage is $25 an hour? So that works out to be $1,800 for the week. If we add 12% for employee taxes and benefits in a real traditional sense, then that brings the wages and benefits for that week up to about $2,000 or therefore around to $8,000 for the month. My question, which is, I think ultimately is a really academic, no-brainer question. My question is, if we had a skeleton crew of 3 people working 6 hours a day, et cetera, et cetera, et cetera, and they're focusing on chart audits and rebooking and rescheduling and some old insurance, would we be able to generate $8,000 worth of income? And I think, again, that's just an absolute no-brainer. And so, again, this is not to be viewed as an expense as much as it's like, well, look, here's the ability to generate $8,000 in revenue. It offsets this. And again, it sets a stage for our greater success when we have the ability to reopen. Additional considerations, unemployment comes up a whole lot. A lot of misunderstandings about unemployment. For the practices, you've been paying into unemployment from the very first day that you were in business. It's a fund, it's there to support people when they are not working. It doesn't matter, especially now, whether people's not working is because of reduced hours, because of a layoff, because of a furlough, because of a termination. None of that matters. And in most states where there is typically a waiting period of a week to 2 weeks, they are waiving the waiting period. So unemployment insurance is something there. It is something where I take a view that says it's there to be benefited from and utilized. And so if hours are being reduced in any form or fashion, I think by all means, people should apply for unemployment. Maybe it just becomes preemptive, because maybe they go to apply and maybe it's going to take a week of processing, and then they're saying, okay, then you'll get your benefits in another week. Well, maybe by then the practice is shifting or changing, or hours can be increased. So at that point, it may not ever be utilized, but I think it makes a whole lot of sense, especially in light of the newest legislation that's being cooked on, which I'll talk about here in a few minutes, especially in light of some of the financial support that this whole stimulus legislation is designed to help and support. Question comes up, what if an employee refuses to work? The CDC defines specific criteria whereby if a person refuses to work, then the employer should honor that. Now, a lot of those CDC guidelines tap into OSHA and safety issues. So if this employee believes it is unsafe, and look, I'm not on the clinical side of this world, a whole bunch of the rest of you are, but I think asking someone to use their mask all day long with multiple people does not cut it with OSHA. And if a person refuses to work because you're asking them to work all day in the same mask, and then you think that because they are refusing to work, you get to terminate them, I think that's just, that just goes back to that spectrum that says, hey, then you're way over on the left. And so if a person refuses to work, you've got to make sure that your safety, your OSHA, and the CDC related protection criteria is in place. If all those things are in place, and if someone refuses to work, and you can still do whatever the work is with someone else, again, skeleton crew or reduced hours, well, go ahead and let the person be on leave. And they can be on an unpaid leave, and no harm, no foul. And when things get back going again, they can come back to work. Just be sensitive to the fact that there is fear, and people are scared about this for both themselves as well as their family members. Here is also, like it or not, a decision or the ability to kind of look at, well, who's coming back? Sometimes you end up with this employee, and you and the employee have been at loggerheads for years, and it's just not working for you, and it's actually not working for the employee. And maybe this is the opportunity, in an interesting kind of way, to go, maybe it's time to make that change. Some of the requirements: anytime you furlough or you lay someone off or you terminate them, you have to give them their paycheck for any hours that they've worked that they have yet to be compensated for. Depending upon the state, there are requirements about how soon that paycheck needs to be given to the employee. In the case of an involuntary ending of employment, that means you, the dentist, made that decision, not the employee. It's typically a certain number of days or on the day that the layoff became effective. There are some times that they'll say it has to be no later than whatever the next payroll is. So just be clear on what that requirement is in your state. And the absolute safest thing is you just give the person their paycheck on whatever their last day of employment is. Then you absolutely know that you're safe, and you don't have to spend any time trying to figure out what your state requirement is. Some of you will have accrued sick leave, where there's been accrued sick leave and it's not been used. Some of you are in states where they have mandated paid sick leave. Maybe you have a policy where it's not mandated, but you have provided some form of sick leave well pay. Just make sure those policies are real clear and make sure that you follow those in terms of paying people out for any accrued and unused sick leave. Same thing applies to vacation and PTO, may be mandated in your state. Then there's also whether you have a policy about it and what does that policy say. States can have varying use it or lose it policies, and so just make sure you're clear with that. Medical insurance. Some of you provide medical insurance. If you do, and now you are either no longer working or there are reduced hours, there are a couple of things to be really mindful of. Built into your policy, buried deep in there somewhere, it will have eligibility requirements. And it will say things like, for an employee to be eligible for this medical insurance, they have to work at least so many hours per week. So you've got to make sure that if you do reduced hours, that you're still complying with this if it is your goal to still have the opportunity for this person to have that medical insurance benefit. If they drop below whatever that criteria is, or clearly if they're laid off, then this can bring into play what's called continuation or COBRA. Now, COBRA, which everyone's probably heard the term, it only applies to employers who have 20 employees or more. And all it is stipulations about the employee has the right to continue on their own. They pay the premium themselves. It can be extended up to 18 months and so on. Again, it only applies if you have 20 employees or more. Most states have in place a piece for employers who have 20 employees or less, and that's commonly referred to as continuation. It, in a sense, is like COBRA. It's just not called COBRA, but it's still the stipulation about someone being able to continue with their coverage. We've had a lot of dentists who provide medical insurance, and they're saying, I want to just continue doing this. I want to cover the medical insurance premium for my employees for the next couple of months. And I think that is wonderful. Again, you just have to check with the policy to make sure that you don't run afoul with the carrier about eligibility. One of the worst things that you would want to have happen is you're paying the premium on behalf of the employee. The employee goes to use the medical insurance, not necessarily coronavirus or anything else, and all of a sudden learn that for one reason or another, the policy has either lapsed or their coverage has ended for some reason. Unemployment comes up here again because some unemployment agencies in certain states require you and the employee to pay out accrued and unused sick leave, vacation, and PTO, and the employee to use that, and that gets calculated in as if it was income. And all they do is then they make a decision about when those benefits will start, thinking, okay, well, you received the compensation for the hours, and now for all intents and purposes, you receive this money for accrued and unused sick leave, vacation, and PTO. And so therefore, we're going to start your benefits at this time. Some states actually require that. An example is North Carolina requires that to happen. Other states don't require that as a stipulation or a condition of someone applying for and working with unemployment. A lot of stuff about the new law, and this is the law that was signed into effect last week. So this is the one that truly is signed and ready to be implemented. The ready to be implemented is because it's still not effective yet. This law does not become effective until, and this changed yesterday, so this slide is now out of date. The law becomes effective April 1st. So they've moved the effective date back one day. It's important to note that this law expires at the present time, December 31st. So this is absolutely just designed to be some interim temporary relief for people, and it is specifically related to COVID-19 and coronavirus. This applies to all employers who have less than 500 employees. There are some possible exemptions that are being toyed with. The ADA has certainly filed for one for dental offices and employers with 50 employees or less. And built in, there is actually some terms, conditions where you can actually file for an exemption if you believe complying with this will force you into bankruptcy or otherwise create undue hardship. The interesting thing is the form you're supposed to file, they haven't even come up with. You're supposed to file this with the Department of the Treasury, and they haven't even said anything about timeliness, criteria for evaluation, and so on. So for me, my recommendation is do not sit around here thinking that somewhere along the line you're absolutely going to get an exemption and therefore you don't have to address or deal with these things. This law has two main parts. It has a sick leave part and it has a family leave part. Now, out in the world, there is a family leave federal legislation, which is commonly referred to as FMLA, for Family and Medical Leave Act. Do not confuse or stir this family leave with FMLA. FMLA was not really touched in this. FMLA still stays basically exactly the way it was. This is a new additional family leave that, again, starts April 1st and goes until December 31st. So don't mix FMLA with this family leave. Relative to the sick leave portion, a person could receive paid sick leave for up to 80 hours. This is assuming the person works full-time, and full-time is defined as 40 hours per week. If someone doesn't work 40 hours per week, well, then this becomes prorated. So in a dental office, if people are only working 4 days a week, 8 hours a day or 32, then that means I'm working 80% of 40 hours. And so the number of hours of sick leave that I would have the potential to get would be 80% of the 80 hours. It takes a 2-week average to figure out what it is. If hours vary, and if there's a lot of fluctuation with hours, they'll take hours over the last 6 months to come up with the average to figure out what the proration would be. To qualify for sick leave, there are 6 qualifying criteria. Please understand, this sick leave is not if you get a cold. This sick leave is not if you get any other flu, virus, or anything other than specifically the coronavirus and COVID-19. No other health-related situation applies for this sick leave. So a lot of people started freaking out as soon as they saw this, because it was like, oh my gosh, 80 hours of sick leave, all my people, I'm going to be financially ruined. Wait, it only applies specifically to coronavirus-related criteria. You'll see on the screen that I have a 3+3. I'll explain that in a minute. It's like there is a key difference between the first 3 qualifying criteria and then the second 3. Of the 6 criteria, the first 3, the employee is subject to a federal, state, or local quarantine. The employee is advised by a healthcare provider to self-quarantine because they traveled internationally, or they were around someone who has been diagnosed, or the person is experiencing symptoms and wants to go to a doctor for a diagnosis. I will tell you right now, because this question has come up a bazillion times, for number one, a closure of a business, mandated or not mandated, does not qualify. It is only if there is a federal, state, or local quarantine. Now, that being said, I indicated that this law is not effective yet. It is designed to become effective April 1st, and there is a lot of stuff running around saying this first piece may get changed to include mandatory shutdowns or closures because of lack of work. But at the present time, closures, mandated or otherwise, do not qualify. The other three, 4, 5, and 6, deal with if this employee is caring for an individual who is subject to a quarantine, or sons, daughters, other family members where schools and child care facilities have been closed, or child care is otherwise no longer available. And then number 6 is, of course, the way our government creates great big gray areas, that if this person is experiencing any other substantially similar condition as specified by Health and Human Resources in consultation with the Department of the Treasury or the Department of Labor. Now, of course, none of this has been defined. No one has any idea what that means and how that will affect qualification. But this is the 6 qualifying criteria. Nothing else associated with an employee's health, well-being, or an employee's family's health and well-being has any bearing on this particular sick leave provision. If the person truly qualifies for criteria 1 through 3, then for the hours associated with their leave, they are to be paid whatever their normal wages are, up to $511 per day. If the person's qualification is criteria 4, 5, and 6, then the compensation for the sick hours that they're out are 2/3 of their wages, up to a maximum of $200 a day. So that's why there's an important distinction between the 6 qualifying criteria. It's also important to note there is no carryover with this. So people are not guaranteed the 80 hours. They are not assured they're going to get that. It's not an issue of if they don't use it, they get paid for it, or it carries over. Once this bill expires, which currently, again, is December 31st, this whole thing just goes away. The family leave portion. The person has to have been employed at least 30 days. Qualification is just criteria 5. Criterias 1, 2, 3, 4 have no bearing on whether someone would be able to take leave under this family provision. So it's only the caregiver part. Of course, that number 6, because it's so nebulous and unknown, maybe it comes into play. We just don't know. If someone qualifies, again, through the caregiver provision, they would have the ability to take up to 12 weeks of family leave. The first 2 of those are unpaid. The remaining 10, or up to 10, they would be compensated at 2/3 of their wages, up to the maximum of $200 per day. And if a person is part-time, they go back and look at a 6-month average to try to figure out what that wage compensation piece would be. So now, if I've done even a reasonably good job of explaining the sick leave portion and this family leave portion, you'll understand how the two of these, at least the way they sort of wrote this, were designed to work together. That the sick leave portion would come into play, it's 80 hours, which is 2 weeks, and the family leave hours, which could run concurrently, but the first 2 weeks of the family leave are unpaid because you would be getting your wages via the sick leave part. And then when the sick leave part runs out, the family leave part would theoretically be there to kick in, but it only kicks in regardless of anything at 2/3 of their wages or a max of $200 a day. Typically with family leave, when I talked about the Family Medical Leave Act or FMLA, typically there is job protection in there, which means if the person goes out on leave and once their leave is done, they get to come back. There is actually a funny little part in this one that there's a job protection exemption for any employer who has less than 25 people. So if someone goes out on this leave, they truly qualify, they go out on the leave, when it's time for them to come back, you do not have to be guaranteeing them a job coming back. And they built that in there just saying, we get that this is going to put a potential stress and strain on businesses, and so we're not going to force you to have to bring someone back if the circumstances and situations at that time mean you can't. Some footnotes. You can't force people to use their benefits, other benefits. Sick leave, this particular law sort of trumps, supersedes everything. You can't force them to use other benefits. You can't force them to find a replacement. You cannot take adverse action against them. If they truly qualify for the sick leave or the family leave, you cannot take adverse action against them if they go to take any of that time. There's some posting requirements that you're supposed to put up. Interestingly enough, the posters aren't even out yet. The qualification, again, and I just want to reiterate this, the qualification for the sick leave portion and the family leave portion only relates to criteria 1 through 6. Not a lack of work, not a closure. It's only that 6 criteria. And while it hasn't been finalized yet, the law builds out that you will be receiving in the form of a tax credit, a reimbursement for any monies you pay out for people who truly qualify and take the sick leave or are out on the family leave. The credit is supposed to be where you just deduct it out of your federal tax deposit that you otherwise make for your payroll. If it turns out you're paying out more than you were even scheduled to pay in, then there is supposed to be a form you're going to fill out, you're going to send it in, it'll be a credit, and they will reimburse you with a check. There's a lot of dangling things with this. Here's one. You closed. You furloughed, laid off, or terminated before the law became effective. At the time you closed, no employee qualified. And now, while after being closed, an employee qualified, are you on the hook? As of right now, the answer to that question is no, you're not. First of all, the law is not even effective. Doesn't become effective till April 1st. And if you were closed, again, because of the lack of business or the recommendations, then you're not on the hook for that. You close. After the law became effective, no employee qualified, now someone qualifies. Are you on the hook? Specifically, if they qualify for 1 through 6, then yes, you would qualify, and then there's still some debate about how that will look in terms of your obligations. The status, someone being still employed, laid off, or terminated now, or at the time of the closure, or the February 1st, now affect the eligibility. And the answer to that is, well, yeah, sure, it will, because were they employed at the time the law became effective or weren't they employed, etc. I have this, we just put this up this morning. This is like the new law. And please understand, nothing's been officially signed yet. It's just been passed in the Senate. It's on its way to the House to be negotiated and tweaked and hopefully passed. The House is saying they're going to take it up on Friday. After they take it up, after it gets passed, then it goes to the president for signature. So there's absolutely nothing that you do with this right now because it's not even in place. It is supposedly around 500 pages long. There are 5 main parts to it. There is money in the $2 trillion to go into the healthcare system. There is bailout money for certain industries, airlines and other industries. There is money that is supposedly earmarked to go directly to all of the citizens of the United States. You, as an adult, would get $1,200 if you make less than $75,000 a year. And of course, they stir things in if you're a married couple and how much your annual earnings are. It phases down and out as income goes up. And there's a $500 check that would come to you for each child. And these are true dependent childs. And again, it has phase out provisions. There is money that's going to go into the state's unemployment system. It's designed to ensure that state agencies have the money to support people when they're not working. In addition to that, the state will do whatever its calculation is of what you would otherwise get for unemployment. And they're saying that in this legislation, then they will take and add just $600 to that for what your weekly total would be. Again, whatever negotiating and debating and all goes on in the House, who knows whether that will turn out that way. And that this additional money on top of whatever the state negotiates would extend for a period of 4 months. There are low interest, no interest, and no payback loan provisions built into this. And as it relates to small business owners and dentists and dental practices, the premise is that these loans could be used for money to, in a sense, keep you afloat and making payroll while your business is closed. And if the money is used for keeping your business sort of alive and well within whatever parameters and specifics they define, then the loan would actually be forgiven. Of our members, Kate Williford clearly is going to be the brainiac for that one in terms of pros and cons and so on. And then there are some provisions built in about oversight to ensure that there's not a misuse of the $2 trillion in this. The 2 parts that are sort of HR related is this idea of more money to unemployment and this kicker of $600, and then the monies to cover continuing payroll while closed down. A lot of questions come up about that of, well, what if I close down beforehand? What if I close? Yeah. And we do not know the answers to any of those things. Now what? And what about next time? You have liability insurance, check it to see if it has a business interruption clause that might apply here. Most of these are going to be, or an idea of a pandemic here is going to land into an act of God. And so the odds are your business interruption insurance may not provide you with any coverage, but it's worth checking. By all means, certainly for next time, build up cash reserves. Dave Ramsey, everyone else, we're supposed to have 3 to 6 months of emergency money sitting around, and you want to make sure that that helps protect you. Explore lines of credit if you don't have them. Banks are being pretty lenient with that right now. afterwards, even when you're back on solid ground, it always makes good business sense to have a credit line, even if you never really tap it, just having it available. An opportunity, as I mentioned, to analyze staffing needs and begin right now focusing on what are your rebuilding strategies and your growth strategies. What are the kinds of things you can be doing right now that set the stage for greater success as things turn around? And clarify your policies and your benefits. Obviously, we do the HR piece for our clients when they've had everything cleanly spelled out in their employee handbooks and their policy manuals. Then there's less uncertainty, there's less turmoil, because they just know what the procedural steps are. So it's a great opportunity for you to clarify policy, clarify benefits, and where your existing ones may be creating confusion or misunderstanding. Again, wonderful opportunity to clarify. So Penny, I'm going to turn it back over to you. How was that?
Okay.
And
Wow.
we'll answer whatever questions we have for our remaining time.
Wow. So I'm going to leave let's leave your slide up for a moment so that folks can get the information down. And then as you're answering questions, we'll pull it down. First, I want to say, Tim, have you even had a chance to sleep? That was a tremendous wealth of information, and how grateful we are that there are individuals and companies like you, like Ben Ericksen, to help us navigate through this, because this is, I hope we never, ever see anything like this again. It's just so consuming. So thank you so much for giving of your time. If you guys want to go ahead, and there is a questions tab. If you haven't already submitted questions that weren't answered, go ahead and do that. Yeah, Tim, if you want to go ahead, if you want to stop sharing your screen as you are doing that, I created a poll. I thought it would be interesting for those of you that are still able to stay on with us here regarding, and I use the term layoffs. So layoff, furlough, basically you're having your team do, or your clients are doing some sort of unemployment. So I'm going to go ahead and launch that. It's anonymous, so we won't know who answered what, but I thought it would be interesting to see how that part panned out. One thing that I'll mention as well, as far as the Academy of Dental Management Consultants, we are reaching out to Kate Williford to schedule a session with her, hopefully next week. Maybe she'll have even more information as some of this shakes out. But again, thank you so much. And one of the things one of the questions that was asked, if the layoffs, furloughs have already taken place, this was one that someone typed in, what do they do if for some reason they've decided, okay, well, maybe I shouldn't have done the layoffs. Maybe I should have been paying out, or with this new piece coming out, maybe there should have been some paid leave going out. What happens if it was already filed and then they realized they wanted to make a different move or decision?
Well, of course, the answer to that is we do not know, just because there's not clarity with respect to the law and the provisions. I think you could say it's a calculated gamble to not lay them off, but continue to employ them and pay, in hopes that that puts you in a better position with this new legislation. But if it doesn't necessarily put you in a better position, now you're paying out monies that could, in a sense, otherwise be paid through unemployment. And I find it hard to believe that they would effectively penalize someone or a business that already had closed or been impacted such that they had laid people off, and that somehow this would make you ineligible for this moving forward. That's really hard for me to imagine. The other is, just like with the current Coronavirus Relief Act, it doesn't go into effect until April 1st, which actually means that there's some number of days where people could still make, for all intents and purposes, some strategic or smart moves that best support their team, their staff, and their practice. The same sort of thing is going to be true with this new one, because once it gets signed, we haven't seen this yet, but I don't anticipate it being somehow retroactive, or it's still going to say, well, and when it becomes effective, or it becomes effective in 7 days, and there may be opportunities to make some moves at that time. And directly to your question, maybe that means I recall people, I bring everyone back.
Yeah, yeah. And by the way, Tim, are you going to be available if we go a few minutes over?
Yes, absolutely.
Okay. I didn't know if you had a hard stop.
Nope.
So along with what you mentioned, and one of the dentists that's actually participating is asking, all right, if we already delivered layoff or furlough letters to our team, would we potentially need to retract the letter due to the third CARES Act bill? And if so, how would they go about doing that?
Again, I don't know. I would just say that if it turns out that that seems to be in the best interest, then I'm not sure it's an issue necessarily of retracting or like going back and trying to undo. It's
like with an eraser, right?
It's more a matter of saying, oh, good news. We get to recall everyone back.
Okay. And then I'm going to
let me interrupt and just say that even with that, we have to remember that we've got CDC guidelines and you've got ADA guidelines about being open and not open. And then we've got states, New York, Oregon, Washington, Michigan, California, that have shelter in place. And so it's like, well, how are you going to say that people are still working when you've got shelter in place or shelter at home? Unfortunately,
crazy dance.
We all would like the answers, and we don't have them.
Well, I think there is some comfort, and some of you may say, wow, Penny, that is a strength. There's some comfort in knowing that if Tim Twigg doesn't know right now, that's an okay answer, right? And when there's something certain that comes out, we know that people like you will advise us. So I wanted to end the poll. About half of the people voted, and I believe the results will come up. I just thought this was curious. So I'm going to read them in case everybody can't see them after I end it. We've laid off the entire team was 21%. Part of our team is laid off. Oh, these are changing. People are still voting. Let me end it. There we go. We've laid off the entire team is now 23%. Part of our team is laid off 30%. We do not plan to lay anyone off 27%. We still haven't decided is 20%. And it looks like that I can share those results with you guys. So, all right. So some other great questions have come in while I'm going to stop this. And Tim, any other comments while I pull up the other questions?
No, pull away.
All right. So let's see. By the way, in case some of you are like, where is she looking? I have 3 screens. So it's like air traffic control. Let's see. Oh, someone says there was a poster issued yesterday. I will see if I can copy and paste that in the link that looks like on departmentoflabor.gov with a nice overview of sick leave and expanded family medical leave. So I will do my best to copy and paste that in the chat.
Yeah, I see one here. It says, can you pay someone for being at home? And the answer is yes, absolutely. If they're working from home or doing telework. It also says if people are participating in CE online or meetings online, I'm assuming it's can I compensate them for that, or should they be compensated for that? The answer is absolutely yes. If the CE is directly related to their given job, then you should be compensating them at their normal wages. If it's system CE that is not directly affected with their job, then you can have a different capacity work rate that we talked about earlier. Yeah, Olivia just posted the link to that poster. Thanks, yes. Olivia.
Yes. So another question coming in, and this is from Deborah Englehart Nash, and I would love to hear you explain this as well. She's asking, all right, if we're not necessarily asking, but sort of trying to require that our team meet once a week on Zoom, do we pay them for that? And then how does that work if it's an office that's furloughed their team?
Well, if you're asking them to participate in meetings, then that is work time and they should be compensated for that. I would question whether you can truly have them then as laid off or on a furlough if you're then also asking them to do some work, even though that work is participating in meetings. I would say it's more of a reduced hours down to only 2 hours a week or 3 hours a week. Again, that does not jeopardize their ability to apply for, be eligible for, and receive unemployment.
Okay. So what if, because I know Deborah's done this, I'm doing it as well. I'm encouraging teams to once a week, maybe have a 30-minute, sort of like we're meeting for a drink. It's not mandatory, right?
Yeah.
But we're going to come, we're going to share what's the weirdest recipe you've made this week with the stuff you have in your pantry, or the strangest question your kids have asked during homeschooling. So as long as it's not mandatory, right? It's kind of like saying, hey, we're going out for a margarita, or we're going to go grab tacos if we could leave our house. There's no risk in that as long as the team knows that it's not mandatory, correct?
The mandatory piece is certainly really key. The other is you have to make sure that the conversation does not deal with work. You don't talk about making phone calls. You don't talk about what are we going to do when we come back. It is, like you said, recipes or who's making the best drink or how are your kids, things like that.
Okay. And then Tim, I'm glad to know that you can see these as well. The question, if my state has a stay-at-home order, can I have an employee go to the office?
Well, it depends on the state's order. So I'm in Oregon. Oregon has a shelter in place or a stay-at-home. I'm currently in the office. Well, if you get deeper into the stay-at-home order, it usually will then have some criteria about applicability. And in our case, it's like, okay, you must telework if you can telework. But then it's like, if you can't telework and it's something that has to be done, then maintain social distancing. And in Oregon, they specifically say, if you're going to remain open because you deem it absolutely necessary, then you're supposed to even identify a person in the workplace who's like going to be your social distancing monitor to help ensure that people practice social distancing. So it depends on how strict and how the stay-at-home or shelter-in-place order was written.
For the state. Well, and I know in Tennessee, my husband works for the funeral home. Now he's not a funeral director. But he's in more like customer service. His company gave him a letter because we were running to the grocery store last night and he was bragging that he had a letter. It's not like he's out and about everywhere, but if he gets pulled over, because right now we're under a stay-at-home order, at least in the county that I'm in, he can say, hey, I have this. I've got to go in and serve a family.
Right.
Okay. So I know now that you can see these questions, Tim, what's the next one that you see that you?
Well, it says, would you please review again the difference between a furlough and a layoff? Just real quickly, Rachel, it's subtle. A furlough presumes everyone's coming back. The business is just on pause. As soon as we're able, we unpause and everyone comes back. Everything's exactly the same, just where we left off for all intents and purposes. In a layoff, the employment relationship ends. And so then there's the ending of employment paperwork. It means when they come back, there's paperwork, etc. So layoff has some uncertainty built into it. A furlough, just by its basic definition, presumes no uncertainty.
Okay. Debbie Castagna is asking for exempt employees, can that decreased work rate, the DCWR reduced rate, be applied to an exempt employee? And from my understanding, exempt would be, this is an office manager that was on a salary.
Well, there's a huge rabbit hole with that one. So there are two classifications that all your employees land in, or one of two. They're either exempt or they're non-exempt. Now, one of the myths and a huge misnomer is that if I pay someone a salary, then poof, they're exempt. And if I don't pay them a salary, then they're non-exempt. That is totally not true. I don't know who made that one up, but someone made that up one day and all kinds of people just jumped on it.
Like me.
Whether someone truly meets the criteria of exempt or non-exempt has to do with management duties. It has to do with the percentage of their time spent in management duties. It has to do with supervisory capabilities and roles. It has to do with decision-making authority and responsibility. That's the criteria that is used to determine whether someone is exempt or non-exempt. It has nothing to do with method of payment, and it has absolutely nothing to do with just the title I give you. I don't get to take the Harry Potter magic wand and just wave it over your head and say, poof, you're exempt because I'm giving you the title of office manager. So the title and method of payment has no bearing on the criteria.
Okay.
So now to the question of, if I have someone who is truly exempt, then they must be paid a salary. And if they work any part of a week, they are to be paid their full salary for that week. I do not get to dock their time unless it's a true reduction in work hours and we sort of renegotiate what their pay is going to be, etc. And you can't just flip-flop back and forth between making someone be exempt and non-exempt and all that just to play fast and loose with it, because the Department of Labor or the Department of Labor in your state is going to slap you for it.
They might even send Johnny No Thumbs after you. You never know. All right. What if you've laid them off and you now want to send them to CE? Do you pay them? How do you handle that?
Well, you lay them off, it ends the relationship. You want them to participate in CE, you're bringing them back. It turns out that the work that they're going to do is associated with the CE. And so, yes, absolutely, you would compensate them for that CE.
And is it state by state? Because I've heard there's so much information flying around from different people. If you brought someone in, let's say you've laid them off, but you brought them in to work 4 hours 1 week. Don't
Yep.
Most unemployment, the team members getting an email every week and they would report whatever income they had, but that wouldn't necessarily mean that they've been brought back?
Correct. All they're going to do is they're going to your question of the UI, asking you, did you work this last week? Yes, I worked 4 hours. What compensation did you receive? And you put that in, and then they're just going to take that into account in the calculation, and they may make an adjustment to whatever you get that next week.
Gotcha.
But it doesn't ding you in terms of, oh my gosh, I'm no longer eligible. All it simply may lead to a little bit of an adjustment in the amount for that week.
I see. I've got a couple more that I see here, and then I see that there's one about an SBA loan, which I think we'll just wait, because not that you don't have opinions about that, but I think that's more of a tax CPA question, and we'll get to the heart of more of what your expertise is. So let's go back to liability, because I've seen a little thread here in some of the questions. Let's say I'm a dental assistant and Tim, you're a dentist, and we go in to treat Mrs. Smith, who sounds like she's got an abscess, right? So you say, okay, Penny, we're going to go in, we're going to treat Mrs. Smith.
Right.
We find out later, even though she wasn't symptomatic, that Mrs. Smith tests positive for COVID.
Right.
4 or 5 days later, I come down with it.
Mm-hmm.
What is an employer's liability in that situation?
Well, it's not so much a liability as much as it says, well, if this happened after April 1st, then you are going to clearly be eligible for the sick leave provisions of the Coronavirus Relief Act. And depending upon how long your symptoms or situation goes on, it may then roll into you being eligible for some family leave of that also.
Okay. So I think only really could there be a situation if I said, Dr. Tim, I'm not comfortable, I don't want to work. And you said, well, Penny, if you don't work for me during this time, you're fired.
Right.
Then we would have an issue, right? Because I could say,
Absolutely.
well, you threatened, I was there, but I was only there because here I have the text message that he says, come in or go look for another job.
Totally. Absolutely. There's going to be some liability on the part of Dr. Tim at that point, clearly.
Yeah. Which we know you would never do that to me because you're
Never.
a great guy. All right. Let's see. I'll let you scroll through. I've been trying to clear them as we got to them and see if there are any others you want to touch on. And I figure we'll probably wrap this up maybe in the next 5 minutes because I know I appreciate your time so much. And I have a feeling we may be calling on you again in a week or so when if you're willing to come back, we'll have some more clarity.
Absolutely.
I think we've touched on one that I see is the employer responsible to pay team members who have children home whose school has been closed under the new Families First law.
If after April 1st, this person is still an employee and schools are closed and or daycare facilities are closed, then yes, this person would be eligible for sick leave under the legislation.
Okay. And then let's end with this one, Tim, but you may have just been pausing for a breath. I want to be sure that you were
I'm done.
finished with that comment. Yeah. Okay. So if a dentist decided to stay open and fully treat patients before anything was mandatory to close, and a team member or patient gets the virus from direct contact at the office, is the doctor possibly liable? If this was before any sort of mandate to close.
Yeah, I just don't know. I mean, we've got a whole lot of enterprising lawyers out there in the world. And so someone can certainly attempt to create a case out of that and appeal to the emotions and all that. So that's above my pay grade to say, okay, yes, no, there's liability.
Okay. And then one other, because I think this is and then we'll wrap it up. And again, thank you so much. And for those of you whose questions didn't get answered, let's just remember how appreciative we are of Tim giving of his time. And hopefully you've got the slide there. That's what they do. I would encourage you to reach out to them directly. And I agree, this is a great time to update your policy manual or create one. And you want a group like Ben Ericksen to do that. So the employee or consent to work is not needed. If you've got team members, going back to our example, if you have team members who are going in to treat emergency patients with the doctor, is it necessary or recommended that they sign a consent to work, or is that understood because I'm coming in?
Yeah, great question. There are some consent forms running around, and some people are thinking, yes, absolutely have them sign a consent form. I'm not sure that a consent form would totally free you from any potential liability because, again, as we talked about earlier, things like OSHA criteria and occupational safety issues are going to come into play. So at the present time, we're not suggesting or saying absolutely you should have a consent form signed. I'm not sure it's going to alleviate or relieve much potential liability, and yet there are forms running around, and if
So
someone
would you advise, Tim, in a case like this is what I say, right? From the best of my knowledge, when it comes to a liability issue, they need to, if there's something, a form like that they're using, the most dangerous place to get it is from your friend on Facebook. The best place to get it is to contact your insurance liability carrier, which I understand dentists are stressed, consultants are, everybody's under, call your liability, ask them, you ask people that you're going to back you up, could it become an issue? Your thoughts on that?
I agree with you completely. If I was addressing this or looking to do this in my practice, I would first say, okay, my carrier, my malpractice carrier or liability carrier, like you said, and the other would be to look to the ADA.
Yeah, that very true, very true. But again, right now, the most dangerous place for you guys to be getting forms, and I hope I'm not being preachy, right? Get them from whoever legally would back you up. Get them from an expert like Tim Twigg, if it's related to HR. Get them from your state dental association or the other if you're really really concerned about it. So
Yep.
I want to thank you again, Tim. You have been so gracious. And it's an honor to be associated with individuals like you in our Academy of Dental Management Consultants. For those of you other members out there, thank you guys. I mean, we're all doing our best to support each other. For the dentists tuning in, it's an honor to serve you guys. We're all in this together. And if we can continue to be of service, there's a lot of great individuals out there on admc.net. There's a directory of the different consultants and what we do. And our greatest goal right now in this time is to do what we can to help, at least on the business side, right? We'll have to have the healthcare people fighting the bug,
Right.
but we want to bring things back to a sense of normalcy as soon as possible. So thank you all so much for your time. Any other parting words, Tim?
No, just thank you so much, Penny. It's been great.
Thank you. My pleasure. All right. You guys have a great day. Stay safe.
Okay, bye.
Bye-bye.